We charged 3 individuals with 2 counts of murder, one for Sharon and one for Bibi Sharon. My lady, in this matter, we have had 42 witnesses testify. We have had exhibits produced, and we have had expert testimony. My lady, it is established that the prosecution bears the burden of establishing that there is sufficient evidence which, if unchallenged, would warrant a conviction. At this stage, the court is called upon. Sorry, my lady. At this stage, my lady, the court is called upon not to make a determination of guilty or innocent, but to determine whether the evidence is adequate and that we have established on the issue of guilt or innocence of the 3 accused persons. But to make a determination of whether the evidence produced by the court, by the prosecution, has established a prima facie case and if it determines that in the positive, to place the 3 accused persons on their defense. My lady, to buttress our position, as regarding the case to answer, an establishment of a prima facie case, it is our position that the 2 murders were due to a combination of connected activities, with each accused person playing a strategic role which they knew and had calculated to be the ultimate final position of death of the 2 victims. My lady, in the High Court case of Republic versus Agre Amegene, 2016, that is on page 18 of our submissions, my lady. page 18. The court determined the ingredients of a murder offense, detailing that the deceased died, that the accused person caused the death, and that at the time the accused caused the death of the deceased, he had formed the necessary malice aforethought or intention to cause death or grievous harm to the deceased. My lady, in our submissions, we have proven death of the deceased through the testimony of PW7, PW1, PW9, sorry, PW7, PW1. Yes, PW1, my lady. That was a doctor. PW9 was our protected witness. PW16 was our expert gynecologist and the mother of the deceased. PW30, my lady. 30. PW30, my lady. My lady, in regards to the evidence of PW16, we urge you to look at his evidence in light of Article 26 of the Constitution that talks about life begins at conception. Article 26, 26(1)(2). My lady, on the issue that the accused persons caused the death of our two victims, we urge this court to look at the testimony of PW9 that links the accused persons, especially second accused, the testimonies of PW 22 and 23, PW 28. Yes, so it's PW 22, PW 23, PW 28, and PW 38. All these witnesses indicated to the court that there was a direct linkage between the first, second, third accused and the death of Sharon, the first, second, and third accused, and the death of Sharon and baby Sharon. My lady, on the issue of malice aforethought, we had testimony from PW30 on the relationship that her daughter had we had from PW9, PW30, 30, my lady. We had from PW9, my lady, on how he became involved with Sharon. And the accused persons. And we had from PW38 who detailed the instructions he was given by second accused and the car he was driving owned by the third accused wife. On the material day in question. My lady? The issue of intent, malice aforethought, has been brought out clearly with the frustrations felt by each accused person, directed towards Sharon and her baby. The preparations clearly by the frustrations of the accused persons directed towards Sharon and her baby. Already the detailed preparations to have Sharon leave her home as detailed by PW30 to go to Gracia Hotel as detailed by PW9 the attempted kidnap of PW9 as buttressed by PW7 when he escaped. My lady, I said PW7 or PW27? I was talking about PW9 when the attempted kidnap of PW9, buttressed by the evidence provided by PW27. Yes, apologies, my lady. And the evidence of PW38, detailing how the deceased, Sharon, was abducted, terrorized, and killed. My lady, we also urge this court to look at the legal precedents and principles that deal with principal offender, precedents and principles. That deal with principal offenders, Section 20 and 21 of the Penal Code, regarding the aiding and abetting principles, and the fact that anyone who is found aiding, abetting, is to be treated as a principal offender, and must be held to the same standard. And must share the same, and must be held responsible, my lady, for the offense in question. My lady, in our trial process, we have provided the court with direct evidence through the testimonies of witnesses. We have provided forensic and medical evidence through our experts, PW1, PW16, and our government chemist, PW3, my lady, PW3. We have also taken you through the crime scene and had witnesses testify on how the body was located. who located the body, and the injuries. My lady, we refer to PW2, PW7, PW18, and 19, my lady, PW19 also. My lady, we also refer you to the false narrative as stated by PW23 and PW24 in relation to the injuries caused to the purported injury and kidnap caused to the second accused and supported by the third accused. My lady, PW23, PW24, PW9 debunked this false narrative. Sorry. Of PW23 and PW24, where the second accused person fabricated an alleged kidnapping, which was supported by the third accused. This clearly indicated an intention to cover up the death of Sharon and baby Sharon. My lady, we urge this court to go through the evidence that we've provided, including the digital evidence, that links the three accused persons to the death of Sharon and baby Sharon, my lady. My lady, we believe that from the evidence provided to this court, the exhibits admitted, we have been able to show the court a network of collaborating evidence revealing how the accused persons working together my lady, abducted and eventually murdered the two deceased. We urge this court to find that there is a clear chain of events that ties the accused persons to the offense in question, and urge the court to consider the evidence carefully and place the three accused persons on their defense melody.